Let's talk non-competes. I'm Brian Barakat. I'm a restrictive covenant lawyer right here in South Florida. And I want to talk today about non-disclosure agreements. On March 17th, 2021, the 4th District Court of Appeals here in Florida released the Therauch Weaver case. And this is an exciting case because it says conclusively that confidentiality agreements and NDAs are in fact restrictive covenants. Why is that important? That means that they fall under and are governed by Florida Statute 542335. And it means each one of those contracts has to comply with a number of important requirements. It has to support a legitimate business interest, which should be spelled out in the contract. It has to have a temporal limitation. It can't last forever. It has to have a geographic limitation. And it has to be signed by the person against whom it's going to be enforced. That's what the contract has to have. But if you're bringing a lawsuit to enforce such an agreement, you need to plead and prove the existence of a legitimate business interest just to get your case in court. In that case, they didn't plead those items. And the case came before the judge for summary judgment, and the court granted summary judgment for the defense, not for the plaintiff. The case was lost by the plaintiff because they failed to plead the appropriate elements of a case under 542335. If you're a lawyer that is constantly writing confidentiality agreements and NDAs, or if you're a business person which confidentiality agreements and NDAs are important, you need to make sure that they comply with 542335. If you have questions about how to draft these contracts or how to effectively prosecute these lawsuits, please give me a call.